Dr. Simmons, a few questions about the evaluation that you performed. You spoke only with Mrs. Calhoun, correct?
In the examining room, that is correct.
And you spoke with no one else regarding her?
I spoke with her granddaughter after the exam.
So you've spoken only with Mrs. Calhoun and the respondent in this matter, Rebecca?
That is correct.
Had you ever met Mrs. Calhoun before?
I had not.
And how long was the exam that you conducted?
Approximately 1 hour.
1 hour. You asked Mrs. Calhoun about her ability to function. Is that correct?
I asked her about
her ability to perform her activities of daily living?
I did, yes.
And is it your experience that people with dementia don't understand or appreciate their deficits? Doctor, let me rephrase that. If someone has dementia, are they always aware of the fact that they have dementia?
No.
Okay. So if you ask someone with dementia whether or not they can or cannot perform a certain task, isn't it true oftentimes that an individual with dementia might say that they can do things that they in fact cannot do?
That has not been my experience.
Doctor, the aid to capacity evaluation was a test that was actually developed for clinicians to evaluate their long-term patients, was it not?
It was developed in Canada. It was developed to look primarily at medical circumstances and then has come to be used for other circumstances. So it's a very valid test, actually.
Doctor, isn't it valid when it's being administered by a patient's primary care physician who has a treating relationship with the patient and some knowledge outside the 1 hour interview?
There's no evidence that who administers the examination is relevant.
Isn't it true, though, that this is a test that was designed to be administered by somebody's treating physician?
How it was designed and how it's currently used is also on a continuum. It's been found to be a very valuable examination to use under multiple circumstances, so I disagree with you.
But doesn't it have its greatest validity when it's being administered by somebody who is a treating physician?
There's no evidence of that I'm aware of.
Yes. Doctor, so to summarize, you met with an individual you'd never met with before.
Correct.
You spent 1 hour with that individual.
Correct.
For the most part, you asked her questions and determined whether she seemed truthful in answering those questions and observed her demeanor, correct?
Except for the objective testing.
Okay. And then you administered a short test, as I said, originally developed for primary care, treating physicians. And then you corroborated that evidence with a short interview with one party in this case, reviewed no medical records, conducted no other tests among the battery of standard tests that we use for neuropsychological testing. And from the basis of that 1 hour and the brief interview and no review of any medical records, you've made a determination. Is that correct?
That is correct.
So do you feel like you made ground?
Yeah, except, he was not going to go where I needed him to go on that darn test. The question is, does she have, on the continuum, rather than thinking of capacity as a bright line, if you think of it as a continuum, the question is, how much capacity does she have? And this doctor is testifying that her stated desire is to have the granddaughter appointed as her agent, as her guardian and conservator. And I represent the other party who has a competing petition to be appointed as guardian and conservator. So I don't want that testimony that court should take her decision, her request, with the same level of credibility. I want to show that she doesn't have the capacity to determine who her guardian and conservator should be. So I am trying to diminish his credibility to soften that statement.
Yeah, but back to what Robert was saying earlier, we didn't show you all of his background credentials, and you can have a local doctor who has enough experience so that the local judge knows that doctor knows. For example, we have a doctor that passed away, Dr. Gregory, used to be my doctor. He called me on the telephone one time. He was just a brilliant person. Called me on the telephone one time, diagnosed me accurately in about 2 or 3 minutes on the telephone, just asking me questions. There are doctors that are known locally who are that good, and I think that's part of knowing your judge and knowing your witness as you're preparing. And I think you did a great job of trying to box him in and limit the facts that he used to develop his opinions, but depending on the level of experience and the level of credibility that he brings into the courtroom, it may or may not do you any good.
But the fact of the matter is he really had only spent 1 hour with her. And the idea that he took her statements, I mean, to me, that's just insane. That, first thing a person with dementia says is, oh, I pay my own bills. And then you talk to their daughter who says she hasn't paid her own bills for 5 years. She has no idea what bills come in. So, that's the issue is I really wanted to show that his idea of questioning the individual and then just deciding whether or not they seemed truthful, that was the way to determine whether or not she could do the things she claimed she could do.
And David almost answered my question ahead of time just a second ago. I was just going to ask for the litigators in the room, do you need to still qualify that doctor as an expert for them to testify about that test? Or are they qualified just by the fact that they have personal knowledge of seeing the subject person, the Lola? I know they can testify as to what took place, but for them to testify about the use of the test and the quality of the test and that kind of the applicability of the test, don't they have to be qualified as an expert first, or no?
Well, he had been qualified as an expert, and unless...
Well, I heard him answer questions about his qualifications, but I didn't hear an evidentiary statement about, we offer this doctor as our expert, and the court say, yes, we're going to allow this doctor to testify as an expert, and
That's
ultimately...
editing.
Yeah, it ended up on the editing room
great.
floor.
Thank you.
Yeah.
But in speaking to most, unless it's truly a very contested, the ward, the proposed ward, is a court-appointed doctor who, in my experience, gets paid $100, and the test is done in 15 minutes. And he does the mini evaluation of 5 questions, and a lot of times we stipulate that in, and then we argue about it. But that's to have 2 competing doctors to come and testify is really not the norm in Georgia, at least in North Georgia.
Depends on how much money there is in the case.
Yeah.
The more money in the case, the more doctors.
And in this real case, I think there were at least 5 doctors. Weren't there 3 in the original Florida proceeding and 2 in the Arkansas proceeding? Mm-hmm. And it ended up they paid the lawyers to go all the way to the Court of Appeals. So this was in this real case, it was hotly contested, and it may have been because they were trying to get Ms. Mitchell to disgorge the money. I don't know what their motivation was for turning it into protracted litigation like that.
But there's the...
Exactly the issue, how much money
Yeah. And here's the issue. If I represent the respondent, and that happens to me a lot where I'll get a call from someone wanting me to come into the case as attorney for the respondent because the respondent doesn't like the petition, is upset with her children, wants to fight the petition. And so I'll meet with the respondent, determine whether or not they think she's got the capacity to engage counsel. I'll enter an appearance in the case on behalf of the respondent. First thing we have to decide is, do we want another opinion? Because I may be better off cross-examining the doctor who gave the initial opinion. If I get a second opinion, it could be a nail in the coffin because it could be a second opinion that says the same thing. Then it's going to be really hard for me to limit this guardianship or defeat it because 2 medical opinions agree with each other. So the question of how many doctors is always a tactical decision, and a point being, since they both found lack of capacity and the ultimate goal was appointment of a guardian and conservator, why would you have a second opinion? Only because in this case, the first doctor was saying that we should respect her desire, her choice as to appointment of that guardian and conservator, and I wanted to show that she wasn't capable of making that decision. I was also going to use the granddaughter's poor decision-making, both with regard to the care of the grandparents and with regard to the financial matters, to show that she wasn't an appropriate agent despite the respondent's desire. And I do the same thing. If I'm representing the petitioner, then I've got a couple of physicians that I will actually, they're psychologists that I will use to prepare a neuropsychological evaluation, and I will always, the doctors that I use have prepared statements for family members to give additional information. And I will always have my client prepare that. Now, the thing about that is, if I give that additional information, normally the other side of the case is entitled to see what the doctor saw in preparing their report. So I have to make sure that there's nothing inflammatory in it. But I will have the petitioner and any other family members who believe that a guardian or conservator should be appointed report some of the anecdotal evidence they have that shows the lack of capacity. So some of the issues that they've seen arise over the last number of years, and they'll report that in writing and give that to the doctor, so that when the doctor is, basically the way the neuropsych works is they give the battery a test, and then the doctor does an interview, and then they review, they compare their interview notes and the results from the battery of tests that probably they didn't do, some lab person did the tests, and then they write an opinion as to capacity based on all of that. I want them to have this additional information because oftentimes that fills in the blank. And especially for somebody who's kind of borderline, it's important. If you're trying to get a finding of incapacity, you want a neuropsychological evaluation that's going to bolster that.
I think that the form exacerbates the problem, but that the problem is this concept of capacity is not well understood by a large part of the medical community, psychologists who are generalists. And there is a group of people working on trying to standardize the evaluation. So what measures are used? What are you actually looking for? What's the consequence of what you found in the measure that you used? But sometimes the form captures exactly the thoroughness of the exam, which, as you said, was maybe 15 minutes or less. But that's a huge problem, huge problem. So you could go to the probate court in one county, it's granted, but that same evidence wouldn't fly in another county. So until we standardize even our understanding of what capacity really is and how to measure it, the form's sort of a side issue.
But that's a problem across the country, and I'll tell you that the problem is that if you read the ABA Commission on Law and Aging's publication on the Capacity Handbook for Lawyers, which is an excellent publication, and you can download it for free from the ABA site if you're a member. If you're not, get somebody who's a member and have them download it for you. They have a capacity handbook for psychologists, they have one for judges, and they have one for lawyers.
It's actually free regardless if you go to the APA website.
Oh, that's right. The APA, the American Psychological Association, offers it free to the general public. So that handbook talks about, one of the most important things is capacity for what? And so because our theory is that we're supposed to go to limited guardianship, we're supposed to be asking the court not for a plenary guardianship, for a guardianship only for the things that the ward cannot do, or in the respondent, obviously prior to adjudication, but that the respondent cannot do, then we should be looking for evidence that shows what it is they need assistance with. The problem, though, and this is the age-old problem, in theory, that's wonderful, but it would take a team of a psychologist and a social worker and probably some sort of a therapist, occupational PT therapist, to follow this person around and then give us this report of exactly what they can and can't do. And so that's the theory sort of up against the practical, which is we're going to have at most a 1-hour hearing in court. We're going to get the cheapest evaluation possible. I'm disturbed that it's the mini-mental. That's awful. That's the worst. And so,
Well,
usually 70%
one of the things, during the break, I was asking our former judge what he thought of this, and he was saying we were getting into the weeds a little bit, but one of the, we're trying to teach here, but one of the problems that we encountered in doing this is the realization that it's not as easy to deal with the limited guardianship case as it is when you are dealing with the plenary guardianship, because we're just attacking capacity, attack, and then it's just who's the better choice if it's a plenary. But here I'm trying to preserve some capacity. I'm trying to, not go all the way here so that I can say that when Ms. Calhoun chose Becky Mitchell as her potential guardian and conservator, that she, her choice is valid and her choice should be honored. And that is a much harder case to litigate than, at least I think it is, than the old plenary standard.
So
Let's go to the next chapter.
Dr. Kirtland, please state your name.
Dr. Michael Kirtland.
Dr. Kirtland, what is your professional title?
I am a neuropsychiatrist.
And Dr. Kirtland, how are you licensed?
I'm licensed through State Medical Board, both here and in the state of Massachusetts.
And you are a licensed psychiatrist?
I am.
And do you have a specialty?
Neuropsychiatry and forensic psychiatry.
And have you testified as an expert witness?
I have
before?
many times.
Many times?
Many
Have you
times.
testified in this court?
I believe I have in the past, yes.
Okay. And in this case, did you conduct an evaluation of Lola Calhoun?
I did.
And as part of that evaluation, did you administer a battery of tests to her?
I did.
And did you interview witnesses?
I spoke briefly with some other people, yes.
Okay. Can you tell me who you spoke with?
I spoke with both the daughter and the granddaughter.
So that would be both the petitioner and the cross petitioner in this case.
I believe that's correct, yes.
So Diana Calhoun and Rebecca Mitchell?
Yes.
Okay. And you interviewed Lola Calhoun?
Oh, yes.
Okay. And did you also interview Lola Calhoun?
Yes, I did a full neuropsychiatric examination of her.
And as a full neuropsych examination, did you conduct a battery of tests?
Yes.
On the Wessler Adult Intelligence Scale, how did Mrs. Calhoun score?
Her score placed her in the 1% category. That is to say that she was severely impaired.
Now, 1%, that would be that she scored poorly enough that she scored worse than 99% of adults of her age.
That's correct.
So she was in the bottom 1 percentile for 92-year-olds.
Yes.
And how did she perform on the memory impairment test?
She had significant memory impairment problems. She was unable on many occasions to tell me without prompting what town she lived in and what town she grew up in.
And how did she perform on the TRAILS A and B test, the test of visual scanning and information processing?
She did equally poorly.
And again, did she fall in a certain percentile?
I believe, as I recall, she was in the bottom half percentile.
Again, in what percentile did she range?
I don't recall off the top of my head. If I can look at my notes, I could tell you what percentile, but it was extremely poor.
Please look at your notes.
Okay. That again would have put her in the last 1 percentile.
Did you have her perform the clock drawing test?
Yes, I did. She had confusion when it came to that. The numbers themselves were done accurately, but she was confused as to how to set the hands. I asked her, to tell me what 10 after 11, to put the clock hands at 10 after 11, and she had significant confusion as to what that meant.
Can you tell the court what the importance of this result is?
Well, the significance is that that from the time we're little children, we're taught how to read a clock. And so it's one of the most deeply ingrained skills that any human being, at least in an educated society such as the United States and Georgia, would have. And so it's a skill that regardless of your educational level, you should be able to perform that task.
On the progression, I understand that Alzheimer's dementia is a progressive disease. How far progressed?
She's quite far progressed. I would say that she has a severe level of dementia.
Now, is an Alzheimer's dementia of a severe level something that happens instantaneously?
Oh, absolutely not.
And so typically, how long is the onset for a dementing condition like this?
You know, there are lots of different types. Even within Alzheimer's, you have early onset, later progressive. It just varies. But even in the most rapidly advancing Alzheimer's disease, it's a matter of years.
A matter of years. So one would assume that her capacity had begun to decline a minimum of...
Your Honor, I object to any assumptions that might be made. We're not here to assume, Your Honor. If counsel wants to ask a question, then I think that's appropriate, but we're not here to make assumptions.
Counsel, I'll sustain the objection, ask you not to speculate. If you can rephrase the question.
Yes, Your Honor. Do you have an opinion as to when the onset of this condition would have occurred?
I do.
And what is that opinion?
I believe that it was at least 3 to 4 years ago.
He was a hard witness, but as you're thinking about, how much time you need to put into getting ready to take on a witness, if you know you've got a contested proceeding, he gave me that kind of trouble, on your direct, and I think you prepared on the drive up from the airport.
Actually, he found out at lunch.
Yeah, at lunch. So, if you've got a witness on the other side that's actually spent some time and you walk into a trial or a deposition without having devoted an equal amount of energy, a good witness is going to eat your lunch. One of the things that we would tell everybody, and our litigators over here know this, but you've got to prepare for cases like this. You cannot walk in and wing it and expect to have a good result.
The main thing I was going for here was the twofold. One is my witness did a much better job of evaluation than Marcus Welby did. He spent a lot more time. He actually reviewed medical evidence, which the other doctor didn't do. He didn't interview just one side of the case. He interviewed both sides of the case. That was important. And he did really a far larger number of tests and had better information. So I wanted the court...
He was a quack, though.
You're going to hurt his feelings.
He says she's in the bottom 1%, and I'm thinking, money. That opinion is so far out there on the edge of the spectrum, so far out there in left field that I'm thinking he's just hung himself.
But what we were trying to do is we were trying to reach back, because it wasn't the opinion at the time of the evaluation. We're trying to undo the gifts. And so we want to show that she didn't, not only were these gifts a product of undue influence, but she didn't have the capacity to execute, to make those gifts. And we wanted those gifts back. We wanted those gifts returned. And so I was trying to basically show that the onset had to be far enough back to have captured the time period when the gifts were made, which was in the last 18 months or so. Most of them in the last 12 months, I think.
Do the next segment before we take any questions on this, because I think it goes together with what we just did.
Okay.
And that would make them more dependent upon the individual that they're relying on for care.
Absolutely.
Now, are you familiar with the research that shows that the relationship between the influencer and the influenced is very similar to Stockholm Syndrome?
Yes, you desire to please the individual in the Stockholm Syndrome situation. The hostages began to identify with their hostage takers. And so you saw the exact opposite reaction to what you might expect. You would think if somebody kidnapped you, you'd resist them. But in fact, they began in that situation, now known as Stockholm Syndrome, to identify with those individuals and support those individuals. And it's been replicated many, many times, both in criminal cases and in diminished capacity cases, that you identify with the person who is abusing you rather than the more, what to the rest of us would seem logical pattern of resisting that individual.
And would you, in fact, in that scenario, state that you wanted to be with your perpetrator and that you have an affection for the perpetrator?
Yes, there are a whole series of influence situations where that's what you see. You see it in abused children. They'll often run to the parent who's abusing them rather than the other parent, because it is better in their mind, it is better to go and please your abuser so that they won't abuse you rather than to go to the person who might rescue you, because you don't know whether they'll rescue you or not, but you know if you don't please the abuser, they will abuse you. Same thing is true with a dependent adult.
You've heard the testimony of Mr. Winter in the courtroom today.
Yes.
Regarding the staggering gifts that were made by Mrs. Calhoun to members of Rebecca Mitchell's family.
Yes.
And basically has devastated her estate by distributing all of her assets.
Objection, Your Honor. I mean, if counsel wants to argue during her closing argument, she certainly has that privilege, but to characterize Ms. Calhoun's voluntary gifts, intentional gifts, as devastating.
Wait, counsel. I'm going to put an end to this quick. Counsel, your question is leading and argumentative. You use devastating and you also use substantial. Whether it's devastating or substantial is my decision. Ask your questions in a non-leading and non-argumentative manner.
Yes, Your Honor.
And counsel, you do not need to give speaking objections. Just state your objections succinctly and I will rule on it. Objection sustained.
You heard the testimony of Mr. Winter regarding the gifts made by Mrs. Calhoun to Rebecca Mitchell and members of her family.
Yes.
Do you have a concern based on the results from your evaluation that those gifts were in fact not voluntary?
I think that's entirely possible. It is impossible to know what was in her mind at the time she made those gifts. However, the pattern that I see in her situation and from what the accountant testified to, I wouldn't be surprised at all, in my opinion, that there's probably those gifts were not voluntary, but rather were intended to please the caregiver so that she would not be abandoned.
Okay, one of the things I'm doing there, remember all the times I said I should have stood up and objected? On this one, and I'd love to hear what Judge McCurry was thinking, but I'm thinking to myself, I need to let him hang himself. He's going so far out there on this opinion with Stockholm Syndrome. Let him hang himself.
That's actually the current research on undue influence.
But there was no evidence in the case
No, there wasn't.
that there was any abuse.
There was evidence that she had transferred all of her assets.
There was evidence that assets had been transferred. There was absolutely no evidence as to how they were transferred or that it was abusive. And there was absolutely no evidence of physical abuse. Move on.
Stop giving me the hyperbole of devastating and this and that, and just move on.
Right. No physical abuse of any kind.
Physical abuse whatsoever, but tremendous emotional abuse, tremendous psychological abuse.
And undue influence never happens in the presence of witnesses. So it's always something that you you're trying to show, and you don't have any direct evidence. So you have to look at things like when a senior gives away all of their money, and they've now devastated themselves financially, to try to show that there's no way that could have been voluntary, no rational voluntary person would have given away everything they owned.
Having
Because several Georgia counties, a probate judge to have lawyers actively going at it, fighting. The judge is not used to that. So he may want to see So that's just know your judge.
well,
And again, you've got family on both sides of the case, so you always have to be careful, because judges don't like to see what looks like a pre-death probate. And so you have to be really careful about how you do it.
let me ask our retired judge, that opinion, that so-called opinion at the end, where our witness said, I wouldn't be surprised at all if, in my opinion, those gifts were not voluntary. Should I have objected to that? I mean, are you going to let this?
If you'd objected, yeah. Sustained.
I would have objected when she rephrased the question to ask him. He had already said, it's hard to tell, I don't really know, maybe, so, it's like he didn't really, there was just no foundation for him to have an opinion.
Oh, yeah.
But number one rule, I learned this in law school, procedures that the professors told me that, so I always try to look at the judge and
Well, and the other thing to remember is, if I'm retained by an individual in the case, and it's a high asset contested case, we've spent over $30,000 sometimes just to get to this hearing. And the hearing itself, the meter is running, my expert is a retained expert, they're sitting with me the entire 2-day hearing, so you know what their bill is going to be. Sometimes there are a few questions I have to ask because my client is expecting me to do it. And, I try not to let the client control the litigation, but there are times when I have to push a little bit harder, frankly, because it's important for the client to see that I'm making a few of the points that the client needs to have made.
Go to the next chapter. Can we agree that if an individual is capable of somewhat complex or moderately complex thoughts, and if they're capable of reasoning out what they would want to do or what they don't want to do, then a test that places them in the bottom 1 percentile or the bottom 1/2 percentile has limited utility?
No.
You heard Ms. Parker testify that Ms. Calhoun was capable of interacting with the medical staff.
Yes.
Now, you're telling us that you spent all of this time. How much time did you actually spend with Ms. Calhoun?
I believe it was about 6 hours.
Okay. During your 6 hours that you spent with Ms. Calhoun, you came to the conclusion that she's in the bottom 1/2 percentile on one test and the bottom 1 percentile on your other tests. And so I guess what I'm wondering is, how do you explain the fact that she was capable of interacting with the medical staff and going, what sounded to me like going to receive appropriate care and directing her own care?
You can interact with the medical staff and correctly give them information on very simple, specific things. I have a headache. My arm hurts. I'm tired. Those sorts of issues which are clearly interacting with the medical staff, and which even I believe it was Ms. Parker who pointed out that at one point she said, I have a headache and I'd like some Tylenol. That's a simple interaction, but it's a correct interaction. But when you do these type of exams, first of all, that's why you do so many different tests. Each one will draw out something a little bit different. And together you see a pattern. Whereas an interaction with the, going to the facility nurse and saying, I have a headache, there's only one possible interaction there, and you've completed it.
Now, is it fair to say that your examination during those 6 hours was your examination, and you would be speculating regarding the progression of dementia over time from whatever beginning point it was through the date of your examination?
Based on medical statistics, yes.
And are you familiar with a prior proceeding in Florida?
I am.
Are you aware that during that prior proceeding in Florida, Ms. Calhoun, the case was dismissed and Ms. Calhoun was found to still have legal capacity?
And by 2 of the 3 examiners, apparently, yes.
Do you have any knowledge based on your examination concerning how Ms. Calhoun came to be in Florida for that court proceeding and how she came to be in Georgia since that proceeding?
I have no knowledge of that, no.
And if I understood correctly, you testified that you believe Ms. Calhoun is incapable of making her own rational decision about where she wants to live.
It is normal for someone to be involuntarily taken from one location to another and be angry about being taken there involuntarily. But when you have someone who has dementias, especially of the level of this lady, you don't know what the motive for any anger they may have is. It may be that rational anger that you describe, or it may be something that has been suggested to them.
I'm just trying to do what I can with this witness. One of the things that we face in Georgia frequently, I think Robert hit right on this in one of his comments earlier, is trial by ambush. I had no deposition. I had nothing to go with, so I'm just trying to chip away at this witness that's been so aggressively against me during your direct. And I'm just trying, I felt like he was out on a limb. I wanted to push him further.
And you did a good job of it.
I was reaching for what I could. You said she's in the 1%. How do you explain these other things? And then I'm trying to limit his knowledge on, the transportation back to Georgia, because we've got other witnesses that are going to testify that, Ms. Calhoun came back to Georgia after the Florida case was dismissed. So I want to make sure this witness can't contradict any of that. Mm-hmm. So that's what I'm trying to do, is at least limit the damage here. Any other thoughts on this?
Nope.
Let's go to the next one. We'd call Lori Parker.
Objection, Your Honor. This witness wasn't previously disclosed.
Your Honor, as we were doing our investigation and as we were looking for ways to bring appropriate information to the court on how to structure the guardianship and conservatorship, assuming the court imposes one, we discovered this witness, and we believe that the information that she would provide is information the court could use in determining the nature of a limited guardianship.
Counsel?
She is not being called for the ultimate question of capacity.
She's being called to state her observations and interactions with Ms. Calhoun.
Is she being called for the question of capacity?
She would likely state what she has observed Ms. Calhoun being able to do and not do, her ability to engage in activities of daily living for herself, as well as any limitations that she may have observed. I do intend to ask her about her observations of Ms. Calhoun's interaction with the medical staff.
Well, counsel, as you know, this is a guardianship. It's a non-jury proceeding. You had limited discovery. Mr. McGuffey, when did you discover this witness?
Just within the last day or two.
Okay. Counsel, would you like to take some time to interview this witness before her testimony?
Your Honor, I would accept the testimony on specific ability to perform activities of daily living, but I would object to the witness being asked to testify on the ultimate question of capacity, as she's not been previously disclosed and does not appear that she has the medical qualification to answer that question. So I would have no objection to specific questions on her ability to walk, speak, things like that, but I would have objection to any questions about the ultimate question of capacity.
Well, the ultimate question of capacity is one for the court, and if this witness has information that is helpful to the court in deciding Ms. Calhoun's, whether a guardian is to be appointed over her and who that guardian should be, anything that is helpful to the court, I believe needs to be brought before me. I'm not going to let procedure over substance as it might affect Ms. Calhoun. Counsel, I will give you an opportunity. We can take a recess for you to interview the witness, ask her any questions that you desire. If you feel that Mr. McGuffey is going too far afield on matters that are not relevant, you're free to object. But I'm giving you an opportunity now to interview the witness if you so desire.
Yes, Your Honor, I'd like that.
So, ever happened to you that you show up in court and here's a witness that wasn't previously disclosed?
Would have allowed it. I mean, I really don't believe I would have allowed it at the 11th hour.
Yeah.
I really don't.
Probate court level at which you have a de novo standard review
Well, one of the things is, until you get your ruling, don't give up on your evidence that you're trying to get in. And even if the judge had not allowed it, you've got to think about whether you want to make a proffer of that testimony, just to get it on the record for appeal. That's always something to consider. But yeah.
That's great. We don't have de novo appeal.
The other thing that I was kind of just wondering where you were going with this, but I was just going to I just let it go. You kept trying to get me to say, is she going to testify on the ultimate issue? And I knew I was never going to ask her that. I know the judge is going to make that decision. I want to put up all of the lay evidence showing what she can do, what she can't do, that's going to cause the judge to reach that conclusion.
And I knew she was going to kill me as a fact witness. I had about 30 seconds of proffer before we started this segment, and I knew exactly what she was going to say. And it was the typical late disclosed witness who's really going to hurt you. And had I had, time to prepare, this witness wouldn't have hurt me the way this witness did, but this witness hurt me.
Was the ward there to testify?
In the real case, yes. And when I was speaking to the attorneys that actually tried this case in Arkansas, the case actually was in favor of Ms. Mitchell and in favor of Ms. Mitchell being a limited guardian or conservator for Ms. Calhoun, because in the real case, Ms. Calhoun testified and did well. The judge decided that she knew what she was doing, even though she had some frailty. So in the real case, yes, but did we have someone that we thought could credibly pull off that part in our mock trial? No, we didn't. So we didn't try that in.
Having the witness there and have her, a lot of times,
The other witness in the real case, and we'll check your question, that I was told caused it to turn in favor of Ms. Mitchell. If we get that far, you probably won't like the witness who played the minister, because he comes across as a little sarcastic and flippant. But in the real case, there was a minister that came in and testified and apparently had a great deal of credibility and was testifying in favor of the Mitchell side of the case.
And again, I really question the capability of the lawyers, because the minister had received a gift a large gift from Ms. Calhoun. So any lawyer worth his salt should have been able to really undermine the credibility of the minister. And I have to tell you, unfortunately, in financial exploitation cases, sometimes it's the minister who is the one who's benefiting the most. So. And that was the key in this case. The fact was that no matter how much I complained, this witness, if they were found to be credible, had current evidence. They had actually spent time with the individual at the daycare center and had evidence for the court on how they functioned at the daycare center. So, in reality, that was a useful witness for the court. And if I were on David's side, I would have argued pretty hardly that this would help the trier of fact. And that it was an important witness for that reason.
You had a question or comment?
Just a technical question. Isn't it only in counties below 96,000 that it's a de novo appeal, and over 96,000 when you have an attorney as a judge that it's direct appeal to the Court of Appeals?
It is counties over 96,000.
Yeah. Over in your county, your population isn't that high. So. But that tells you another thing is you've got to know what's the jurisdiction in your court as you. We probably got time for this last chapter, and then we're going to dismiss you after we talk about it. Let's do the next one. Now, did you find any evidence of undue influence, someone essentially twisting Ms. Calhoun's arm to get them to give her any money?
Objection. This witness does not qualify as an expert in the area of undue influence, simply fraud, correct?
He is an expert in fraud. I asked, did he find any evidence as part of his review, and he hasn't answered that question yet.
And the answer is,
Wait. The objection is that he's not competent or qualified as to the area of undue influence.
Correct.
And was this witness previously disclosed as given testimony as to the area of undue influence, counsel?
Not specifically, Your Honor. He was disclosed as a fraud expert, and I would argue that undue influence is a subspecies of fraud that this expert is qualified to testify regarding.
Well, he's already testified that he found no evidence of fraud. And that was the area of which you disclosed this witness. So if you had had any Daubert motions, you could have made them if you thought he was going to testify as to undue influence. Correct, counsel?
Correct. There was no information that this witness would testify as to undue influence. He was certified as an expert. He was disclosed as an expert in fraud and forensics examination on fraud alone.
Counsel, I'm going to limit his testimony to the area of which you disclosed him. If you wish to have this witness testify as to undue influence, you should have disclosed it prior to trial.
Well, that'll teach me. Thank you for coming. We have kept you here for 12 hours between yesterday and today. If you liked what we did, if you want to see this again, shoot us an email. Let us know what you think we can improve on, what you think we can do better, what you'd like to see different. And I appreciate your coming.